So what I wanted to talk a little bit about this afternoon is about people's welfare rights with regard to cardiomyopathy. It can be a tricky area when you are trying to navigate the benefits system or looking at challenging a decision when you've applied for a benefit and that you haven't been successful. We're also going to touch a little bit on the nature of disability. So for some people ring our helpline and they say, is cardiomyopathy a disability? Am I now rendered disabled because I have a diagnosis of cardiomyopathy? So we're going to have a little bit of a look at that as well, and looking at the Equality Act, and then kind of rounding up on how the charity can support you. There will be time at the end for questions, so if you have anything that's really, really pressing, please just shout out, or we can wait to the end and we can discuss it. Okay? So when we're talking about the Equality Act, I used to run this session on Zoom as a webinar when I was at the charity, and that would go out globally. So I've kind of put this caveat up because we used to have an international audience when we were online. So the Equality Act is only for the UK, so I don't think we need to say that here, but that was for when we were on Zoom. Okay, does anybody know what the Equality Act is? Yeah? Does anyone want to describe the Equality Act or what they understand the Equality Act to be?
It's part of legislation that covers 9 characteristics.
Perfect. Yeah, should we just swap seats? Yeah, that's exactly right. The Equality Act talks about the 9 protected characteristics. There is talk that, and we'll look at those shortly, but there is talk of an extra characteristic that is being debated at the moment, and that is menopause. So that's not actually enshrined in law at present, but there is discussion which is focused primarily around making menopause the 10th protected characteristic. Okay. So why is the Equality Act so important for people affected by cardiomyopathy? Okay, so the protected characteristics, I'll show you a list of those shortly. And the Equality Act means that anybody who has one or more of the 9 protected characteristics is protected in law against discriminatory practices or discrimination. Okay. We will be looking at disability as our primary characteristic today. And it's important to note that just because somebody has a diagnosis of cardiomyopathy doesn't automatically make them disabled. And it also means that somebody with cardiomyopathy might start their journey with cardiomyopathy and not be disabled, and their health might change over time, and that characteristic of disability then becomes applicable. And likewise, it can change again, depending on treatment or management. So there are the 9 protected characteristics. Are those kind of what you would expect to see? Yeah? Okay, so where does the Equality Act apply? So where can this be used? So the kind of predominant area that we will be looking at today is employment. So employers are not permitted to discriminate on the grounds of any of the protected characteristics. Educational settings, so and that applies to obviously primary schools, secondary schools, colleges, further education, and it's at all ages. So it's as applicable to a mature student of 64, 78, 52, 40 as it is to a child of 3. Okay? And public services, as we would expect. So the council, the NHS, they cannot discriminate against you on grounds of any of the protected characteristics. And also in the wider public. Okay? So virtually everywhere, really. I don't know why they've broken it down in the law as this, and this, but virtually everywhere. Do we understand what discrimination means? Can anyone give me an example of what discrimination might mean? Okay. So one of the things that I used to hear on the helpline quite frequently was people would say, I'm being discriminated against by my employer. You have to be quite careful when you talk about discrimination, because it is, as it is a term in common parlance, it's also a legal term. And when you suggest that an employer is discriminating against you or is involved in discriminatory practices, you have to be able to evidence that discrimination under the protected characteristic or characteristics. So that's really, really important. We used to have people say, I'm being discriminated against. And then we would ask, how is this discrimination manifest? What could you see? What is happening? What have you... And it wasn't actually discrimination. So we have to be quite clear on that. We understand discrimination, and the law understands discrimination as when somebody or a collective treats someone unfairly or disadvantages them because of a protected characteristic. So not in spite of, because of. Okay? It's not about, and as it says there, it's not about different treatment. So if I have a company and I say, right, everyone must move, everybody has to use the stairs except for people who have a walking frame or they might have mobility needs, then they can, of course, use the lift or, you know, whatever is easiest for them. Okay, so I'm treating the staff differently, I'm treating people differently, but I'm not discriminating. I'm treating them differently to treat them equal. Okay, so this is just a little thing to get us kind of in gear. So I just want to have a little look at these, and then we can kind of decide who is being discriminated against. So Joe's 43. He's been informed by a holiday rep that he can't book an 18 to 25 holiday as he's older than 25. Aisha is a practicing Muslim and has been made aware of the prayer room upon her induction into a new job. Carlos has transitioned from male to female. His employer has told him he must use the female toilets as he was born a woman. Shirley is 93 and has been prevented by a bank worker from signing up for internet banking as it might be hard for her being an older lady. Sven is a male and has applied for a job to run the local women's recovery from abuse group. The application stated no men were allowed to apply for the role. Okay. Who's being discriminated against? Wow, Shirley and Sven, Shirley and Carlos. Carlos is being discriminated against, yeah. On what grounds is Carlos being discriminated against? Sorry? Yes, yeah, that's exactly correct. And who's the other one? Shirley, yeah. Okay, so Shirley's being discriminated against on the grounds of age, yeah. A domestic abuse charity for women. And one of the caveats that whenever we put out a job, when we advertise a role, we have to put that only females can apply. And then we put that it's because it's exempt, it's specified under the Equality Act that we have to have females only for that role. Okay. What about the different types? Do you think there's different types of discrimination, or do you think discrimination is off? I can see Leah nodding in the back. Yeah? So do we think there's different types, or do we think discrimination is just discrimination? Yeah. Okay. So these are the types, and this is what the law looks at. So if you ever take an employer to a tribunal, this is what they will be looking at. The types. So indirect. As it states, this is a rule or condition which applies to all that would put someone with protected characteristics at a disadvantage. So there we go. Everyone has to use the stairs. Well, but I'm in a wheelchair. Doesn't matter, you've got to use the stairs. How am I going to... No, everyone's using the stairs. Okay, that's indirect. That's the ruling, and it's not making allowances to treat people differently in order that everyone is treated equal. Okay, so that's the indirect. Direct, so that's obviously what we would probably see more visibly, is treating someone with a protected characteristic worse than someone without, just simply based on that characteristic. So say if somebody comes to me and they say, I have cardiomyopathy, and my illness is such, my condition is such that I'm now classed as disabled, and then I have another applicant who has no disability. By me saying, you know, the person with cardiomyopathy is the wonderful super person with all the requisite skills, knowledge and experience, but I say, no, I'm going to go for this person because I don't want the one with cardiomyopathy because they're disabled. Okay, so that's the direct. Associative, now this is quite difficult to prove, but it is nonetheless recognised in law. So this is when you have a connection to somebody who has a protected characteristic. So that's, you know, again, if you decide that you're not going to employ a carer or a mum or a dad or an older sibling who has caring responsibilities for a disabled child. Okay, because you are assuming that they're going to take loads of time off, or they're not going to be able to be around on weekends to work or in evenings, or they're going to be unreliable, or they might cancel things at the last minute. The assumption that these will happen because of their caring associations. Okay. This one's a more subtle type of discrimination. So this is based on the perception. Okay. Again, this one can be quite difficult to prove because it is a perception. It is based on the perception. So as it suggests there, if I have, if I have a long list of names and I see one and I think, oof, that doesn't sound right, or oh, that sounds like that's from a specific community, I don't want those. I won't even bother to interview those. That's based on the discrimination on perception. And then we have the more obvious one, which is harassing somebody because of a protected characteristic or a perceived protected characteristic. Okay? Does that one kind of make sense? Because it's not just if you have a protected characteristic, but if you are perceived to have a protected characteristic. Now, this is the one that we're going to be kind of looking at, is reasonable adjustments. So reasonable adjustments is where the employer has to, as it suggests, make adjustments where practicable to the workplace or your work regimen so that you are supported with your protected characteristic. So, is it or isn't it? Is it a disability? Huh? It is individual. Okay, so again, this has come up on the Cardiomyopathy UK helpline quite frequently in the past. Am I now disabled? No? Okay. So this is really, really important. And the problem with the Equality Act is it is, as most laws are, quite dull, quite long. It's written in very understandably legalese language. It has loads of caveats and kind of addendums to it. But the working definition and the legal definition of a disability is someone has a disability if they have a physical or mental impairment. I mean, you just have to look at the language of and that's 2010. So a physical or mental impairment that has a substantial and long-term adverse effect on their ability to carry out normal day-to-day activities. So I've kind of broken those down because when you actually explain that to people when they're speaking on the helpline, they're like, well, what do you mean by substantial? What's a mental impairment? What's it, so we have to break that down. So impairment, so that would include the impact of medical and long-term conditions. So cardiomyopathy might come under that if it affects you and it affects your kind of daily living. And substantial means that it limits your activities. So it's not that, or I have trouble getting out of bed, but I can after about 10 minutes, or I have to have it has to affect you to the point where you're not able to travel, or you are, so some people can't travel because they are on diuretics, or they've had their license taken off them. These are all kind of significant limiters. Long term, has lasted or is likely to last at least 12 months. So that's the really, really important bit. And when they're talking about day-to-day activities, it suggests what your daily life is like. So it has to affect these areas. Yeah? Is that clear, or is that... It can be a little bit kind of difficult to wrap your head around, but it's kind of... Anyway. Okay.
Is that based on you as an individual, or the man on pathologist type general person?
It's dependent on the individual, very much on the individual, yeah, and how the individual presents. Yes, yeah, absolutely. So the Act doesn't have a long list of impairments, because to simply do so, you'd be here forever and a day, and you'd be forever updating it. There are certain conditions, as it says at the bottom, that are automatically render somebody as disabled under the Act. So we're not talking about self-perception, but under the Act. So that's HIV, multiple sclerosis and cancer. The Act does cover mental health as well as physical health. And it focuses on the effects, not the condition, which is what we've said. So somebody with cardiomyopathy isn't automatically rendered disabled. However, somebody with cardiomyopathy that is substantial and affects daily activities significantly, that is where the disability comes in, and it's lasted or is likely to last 12 weeks. 12 weeks? 12 months. Okay. All right. So that's basically what I've just said. One of the other questions that we used to get really, really frequently on the helpline is, do I need to tell my new employer or my existing employer whether I have cardiomyopathy? This question was kind of asked more frequently and perhaps more urgently over COVID. So we found that a number of employers were going around saying, look, if you have a medical condition that we need to be aware of that you might not have disclosed previously, can you tell us, blah, 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 blah. So people were in a kind of panic. Do you think you have to disclose cardiomyopathy to an employer? Okay. You have no legal requisite to disclose unless it is something you're undertaking a kind of quite strenuous role that would put you at risk. And I think that's kind of obvious. I think that if you were applying to join the military, you would have to have a medical anyway, and the cardiomyopathy would show up, and so that's kind of renders that redundant. But anything that is particularly stressful and taxing and onerous, like those, the armed forces, the police, etc., then you would have to disclose. But other than that, you don't have to disclose. And one of the things that you need to kind of be aware of is when you apply for a job, and I've seen a couple of these, is that some employers can be a little bit sneaky, potential employers, and they can give you an application form and it will ask you about your health. If it's not one of these roles, you don't actually have to answer, and they shouldn't actually be asking that. Okay, so if you do see that on an application form, you are under no legal obligation, to be clear, to respond to that. Yes, of course.
You've got an ICD?
Yes.
Would I have to tell the employer that I've got an ICD? Because if I'm up with my job, of course, I was on site.
Yes.
I was about that as if my ICD went off, I'd be at danger, wouldn't I?
You don't have to disclose, but as we're going to just literally the next slide is sometimes it is advisable for your own safety. Do you see what I mean? Your own well-being. But no, you don't have a legal requisite to disclose that. Okay. So why disclose? So if you have to have reasonable adjustments, like maybe, I mean, for some people, I know that if they're particularly fatigued in the morning, they would be allowed to start work a little bit later and then finish a little bit later. Some people had the opportunity to hybrid work more frequently if they had, as a reasonable adjustment. Also having access to an open window in the summer so that they're kind of, there's enough ventilation and circulation. So all of these that you might not think are reasonable adjustments, but in fact are. Okay? So if you want to ask for reasonable adjustments, you would have to disclose why you need those reasonable adjustments. Also as well, I think, and it's completely up to you, but I know that speaking to some people, they've had to kind of disclose, well, they haven't had to, but they've chosen to disclose to their employer that they have cardiomyopathy because they've needed time to attend medical appointments and also to make the employer aware in case something goes wrong or that they need some extra support, or like you yourself have said there, sir, about having an ICD. It might be a good idea so that they are aware, and if it fires, that they can kind of, they know what to do and they can support you. Sometimes people disclose because to raise awareness, and I know that a lot of our supporters have done that. They've shared that they have this condition and what it looks and feels like and how they can be supported, and that raises awareness. And if you do feel that, you know, if you have a disability or the cardiomyopathy has is such that you have a disability because of the symptoms and the treatment, then you are protected under that Act. So then you would disclose it if you were kind of taking action. Okay. So that's what the Act says. So, it is kind of common sense. It's when people make adjustments that they can make as an employer to make your life, make your work easier. Unfortunately, some employers might not be able to make reasonable adjustments. So, say for argument's sake, you're a HGV truck driver, and the DVLA says, no, you can't drive anymore. You can't, because of your cardiomyopathy, you can't be a truck driver anymore. If you work for a small local firm and you say, right, I need some reasonable adjustments, they might be, a 3, 4, 5-person firm, and they might not have opportunity to make reasonable adjustments. They might not be able to have you in as office staff. They might not have that requirement, have that need. So sometimes an employer can't make a reasonable adjustment. And that's the law is quite clear on that reasonable adjustment should be just that, and it doesn't require an employer to change their whole entire business to suit a person's needs. Okay. And like we said, it's often practical in nature. It's often kind of basic things that employers can do to just kind of make the working day and the work a little bit easier for people with cardiomyopathy or a disability. If reasonable adjustments can be made and the employer refuses, that could be a ground for discrimination. Okay, it could be, depending very much, as all things are in law, depending on the situation, on the reasoning, but there is possibility for discrimination to have occurred. Okay, and these are some of our examples. So these are all practical examples that these are from real people who have cardiomyopathy, and these are some of the reasonable adjustments that the employer has made. That's an important one as well, is having a lot of people with cardiomyopathy have said that having a car parking space at work that's quite close to the building has been really, really helpful, so they don't become kind of fatigued or the kind of breathlessness isn't increased. So all of these different things. Okay, and that's the reasonable adjustments are based in context. Okay. Moving swiftly on to my favourite subject, Has anyone applied for PIP? Obviously, you don't have to. I should have said you don't have to say, but yeah. Was it easy? Was it fun?
I didn't get it.
You can get it?
No, because the stupid test that done was, can you move your hands like that? And can you walk to that wall? Well, that day I could walk to that wall, but I had heart failure previous to that when I filled the documents in.
Yeah. How about you? Was it fun? Was it good? Okay. So, and on those positive notes, PIP is personal independence payment, and it is for people who have health needs, and it applies to physical as well as mental health. We're going to have a little look at, when you said about what you just said, then we're going to have a look at some examples of that. Okay, so we're just going to be looking at PIP today because we don't want to go through all the benefits because we'll be here until tomorrow and I'm sure you wouldn't welcome that. It is the most common benefit within the cardiomyopathy community, which would make sense because it relates specifically to people who are affected, their well-being is affected. Now, it's controversial. And why is it controversial? Okay, so we had a client, Cardiomyopathy UK, about 4 years ago. The client was very unwell. They had been refused they needed a heart and lung transplant, but they were refused, saying that they couldn't do that for this client. So they said to client, we'll call the client X. They said to client X, no, we can't do that. So it would be palliative care. Okay, so she was terminally ill. She was a very, very poorly lady, very poorly. She applied for PIP, and then she had a PIP assessment, and this is the absolute truth because I saw the report. So the palliative care doctors had said this person should have PIP. The cardiac services said yes, respiratory service yes, and the PIP. The DWP assessor at the PIP assessment said no because X scratched her head like so during the assessment, showing good motor use, upper body motor use, and was refused on that ground. So I am not at all surprised. I'm horrified, but I'm not surprised, and that's why it is controversial. What do you think? So obviously with PIP, you do a massive application, and it is huge, isn't it? It's amazing. It's huge. Okay, and what qualifications do we think the DWP medical assessors have? Do we think they're Do we think that they're cardiac surgeons? Do we think that they're incredible cardiologists? No. Now, this isn't to bash the DWP assessors, but the issue that I have, and I know that a number of organisations for their respective client groups have, is that when somebody applies for PIP on the grounds of cardiomyopathy, a community psychiatric nurse is possibly not the best person to assess somebody's cardiac function. Likewise, if somebody, if somebody has a diagnosis of bipolar disorder, it probably shouldn't be a physiotherapist who is assessing the bipolar. And I say that because I have seen that the different assessors that we have worked with have unfortunately not had I'm not bashing them, but they haven't had the requisite knowledge to look at cardiomyopathy when it's somebody presenting with cardiomyopathy. So these are the eligibility criteria. And you can find all of this kind of stuff online. Okay. So this is why it is controversial and it's difficult, because some people, there's a kind of a bit of confusion, I think, around PIP, because some people have rung up the helpline in the past and said, I'm not symptomatic and I'm living my best life. Well, they haven't said that, but they've been non-symptomatic and everything's fine and they're working, blah, 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 blah. And they've said, you know, am I going to get PIP? And we've had to be quite honest and say, not a chance. And you probably shouldn't, because you're not, your needs aren't such at this time from what you and your clinicians are describing going to meet that eligibility criteria. So the assessors, they can be paramedics, occupational health therapists, community psychiatric nurses, disability specialists, but they're not necessarily going to be cardiac trained. And again, I'm very clear that I am not bashing or criticising anyone's clinical knowledge or their position, but I do think that, and we've written to the DWP before, the charity has to state that when you are assessing a heart condition like cardiomyopathy, you need somebody with the requisite knowledge, experience and skills to assess cardiomyopathy. Okay. Some of the issues that we do see, or we have seen with clients, is that applying for benefits can make people feel, one person said to me, I feel quite dirty. And I said, how that's interesting. What do you mean you feel dirty? And this person had said, I've never, I've worked all my life, I've never had to claim benefits, and now I feel like, I feel quite sort of dirty and that, and then I haven't got it, so then I think, oh, do they think I'm a fraud? Perhaps I don't deserve it. No, I don't think I should challenge them. And that's absolutely not right. PIP is there for people who need it, and it should be given to people who need it. So some people do feel guilty. They're like, oh, somebody I know is worse than me and they don't get PIP and I don't think I should apply. And people can get quite angry. And, I would say, understandably so, because you're having to go through this rigmarole time and time again, and then you have somebody saying to you, no, like you scratched your head, so you're obviously hunky-dory. And it's like, well, I'm receiving palliative care. No, you scratched your head, so you seem all right to me, off you go. So it can lead to anger, and that's understandable. Did anybody hear about this? Okay. We saw a number of rejections about 2 or 3 years ago. People were being rejected, quite poorly people with cardiomyopathy who really needed PIP and certainly met the criteria by what their clinicians had said, what they had said. And then that came out. The DWP admitted that they rejected disabled people for benefits at a record rate. So flaws in the system have led to almost 80,000 PIP applications that should have rightly been awarded, were rejected. But again, it comes back to, if you have the right people, that's part of the system, right? If you have the right people in assessing the right conditions of which they're trained, knowledgeable and experienced of, then perhaps we wouldn't get this. Okay, so just to round up. So the charity can help. So consign to the most appropriate service. So that could be citizens' advice. That could be any of the kind of smaller rights organisations. Can ascertain if you're eligible. The Citizens Advice website is really, really good. I have to say it, and I don't mean like the local one, I mean the general one is really, really good. And it's updated very, very frequently. And I know this because I used to be a volunteer assessor many moons ago. So they update it all the time. If you do choose to disclose your cardiomyopathy to an employer, the charity can help you to do that. I think of ways how to do that, and support you to request those reasonable adjustments, as well as writing supporting letters if you give them enough time. Okay, so you obviously have to kind of, if you know you need some paperwork doing, give them enough time. One of the things that I would say is the best advice, if you're applying for PIP, I think it's question 15 or 16, okay, on the PIP form. That is all it says on that page is any additional information, and most people just flick through it because what it's asking you all the way through is tick boxes, and then people just flip that over. Use that page. Absolutely use that page and explain what your life is like from the minute you wake up to the minute you go to bed. And as it says, if you need extra paper, use that, okay? Because if it lands on somebody's desk who doesn't have any experience of cardiomyopathy and they just see a form like that and it says, oh, Joe Bloggs is on ramipril, okay, is on bisoprolol, yeah, can walk 50 metres, yeah, okay. It doesn't tell them anything and it's most likely just going to be a... If you explain, however, if this is true for you, you know, obviously adapt it to your own needs, but do you wake up in the morning and do you feel refreshed? Or do you feel like you've had a fitful night's sleep? Do you wake up in the morning and think, oh, that was good, I feel great now? Or is your heart already kind of palpitating? Are you already feeling palpitations? Do you feel rested? When you're putting on your slippers or you're putting on your clothes in the morning, your tights, shoes, trousers, is that causing breathlessness? Could you go downstairs and make a massive fry-up? Or would that be too onerous, standing over the... You've got to be thinking about all of these and explain it in detail. You know, what about would you be able to run for a bus? What about when you get to work? Do you have to use the lift? Do you have to use why can you not use stairs? What about public transport being on diuretics? All of these things. So from the minute you get up in the morning to the minute you close your eyes at night, and explain what your day is absolutely like. And what I always tell people as well is if you look at the Cardiomyopathy UK website, say if you have hypertrophic cardiomyopathy, at the top of the fact sheet on that page on the website, it will tell you 3 lines about what HCM is. Copy and paste that across if it's HCM. Same if it's DCM. Same if it's Takotsubo, whatever cardiomyopathy it is, because then you are explaining in layman's terms to an assessor who's probably never heard of cardiomyopathy exactly what that means for you. Yeah? Okay. And then go into your day. And just... Brilliant. Thank you. Okay. So some of the things that, unfortunately, the charity can't do, it can't provide crisis loans or travel to clinical appointments. It can't help with life or critical income insurance. We get asked that quite a lot. We can't write benefit applications or attend tribunals. But there are plenty of things we can do. But like I said to you, if you remember nothing from today, remember that PIP form, because you never know when you might need it in the future. It might be for a short time, it might be for a long time, it might be not at all. But question, I think 15 or 16, you'll see it. Remember that one. Okay? Ta-da. Has anyone got any... Do you all like this? Yes.
It's more of an observation. I think no more than during the COVID period did they really become obvious about how... I don't want to use the word discrimination, but I will. Okay. I think the government looks at different conditions. So, I mean, I'm not putting myself in this group, but I wouldn't say I would have been in that category of people who had to stay at home during lockdown. But considering I know people who have really bad symptoms, there was never a letter, unless maybe some people did get it. I'd never got the letter that said, you know, you've got to stay at home and so on and so forth because you're at high risk. Mm. And yet, when it's the flu season, you get the letter to say you're at high risk, you need a flu jab. And I just don't know who makes these assessments about these kind of things. It makes you almost feel like a third-class citizen to some extent in the hierarchy of medical conditions, you know?
Yeah, I do. And back when, because there was the letters about shielding, wasn't there? There was the shielding, and I mean, I'm sure Ian would attest, our Facebook group was just, because some people who were virtually symptomatic were kind of getting these letters like, you need to shield, and then people who were a lot further on in their journey and were quite poorly and received nothing at all. Then some people received it like 4 months later. Some people received it as soon as the announcement was made public. I think it was ill thought out. I honestly think I think if they were going to do it again, you'd like to hope that they would have learned. But I certainly, and a lot of people were saying that as well, just to pick up on your point about the third-class citizen. You're not the only person to say that. Quite a few people had said, if it was cancer or if it was something else, then it would be, every precaution would be taken. But cardiomyopathy, not so much. And yeah, I've certainly heard that in the majority.
Other questions or points that people would like to raise?
So I was helping my dad with his application, and obviously I know can't go into detail, but basically the appeals process felt like a bit of a dead end, which was a bit intimidating process and stuff. Do you have any advice about?
Where are you in the? Are you a mandatory reconsideration stage?
I think we just got like a rejection letter, and then we didn't know what to do next. Really, it was a bit.
How long ago was that?
2 years. Was it? No, a couple of years ago. 2 years ago.
I would encourage you to put in a new application. I really would. When they kick it back, then you apply for a mandatory reconsideration. And then if that doesn't work, then you go to tribunal. What I will do is I will give you my card afterwards, and you can email me. I hope that's all right. And I will so I can explain properly the process, because I have a document that explains it. Would that be okay?
We really appreciate it.
Not at all. We don't want any troublemakers or rabble-rousers.
So I've had PIP for like 6 years.
Yeah.
I've had to reapply a few times, and I had to reapply in June, and they said no. And I did the mandatory reconsideration and got standard for both, but this week I had to get my car back, which was really sad, and I didn't really know. So I did the mandatory reconsideration and got a bit more than I originally got, but I now don't get as much for mobility, and I don't really know. It said you have to go to tribunal, and I was like, I don't know what that really means, and I don't want to do that.
Tribunal. So, do you know what I would say, based on professional experience of tribunals? Go. Absolutely, and I'll tell you why. So a tribunal is, they do quite a lot on the phone now, because they had to over COVID, and that's because before it was at the local court, and then now it's sometimes you can do it on the phone. And what it is that they have an independent medical person who's not related to the DWP, and they have a judge, a tribunal judge, and they might have somebody from the DWP there, or they might not. It just depends how. But 9 times out of 10, and I say this on professional experience and experience of colleagues that work in the welfare sector, the judges generally are more amenable because they hear the person and they get to ask you things, and when you get on the phone, it can be a bit sort of, the usher will come on and say, please do not make a recording because it is an illegal offence, and you think, but actually, I would encourage each and every one of you, if you are in a position to take it to tribunal, go. It's not, you're not on trial. They will ask you questions. They give you opportunity to expand, and seriously, it is well worth doing. Take it to tribunal.
So I think I've missed that point now, potentially. It was a few months ago. And how, can I reapply, or do I have to do a whole new application?
I have to. You can make a request under extenuating circumstances, because you have a month from the point of a mandatory so that there's the application and the rejection. First tier appeal is mandatory reconsideration. Third tier, final tier, second tier, final tier is tribunal. And you have a month with each of those. If it's out of the month, then you can write an extenuating circumstances letter and request that the mobility component be reviewed again. However, I have to make it very clear to you that whenever you ask the DWP, and this applies to everyone, to look again at any benefit, you could run the risk of them reducing it down.
Yeah.
I'm not saying that's a reason not to.
No, I know.
It is your decision, but just bear that in mind. We can talk about that after if you want.
Thanks.
Anybody else?
In regards to employment, if there's a job that you want a job and it says it's only open to people with disability, could we still apply for those type of jobs?
If it says it's only open to people with a disability,
Well, you know, in job sites that say for disabled people, there's a website for disabled people's
yeah.
jobs, so I can still apply for those, can I?
If it's saying that it's they're only looking for disabled applicants, you would have to have a disability. So if your condition is such that under what we've described as a disability, then you can. If it is at a place where it isn't, then you wouldn't be able to. Does that make sense?
The symptoms basically can make it a disability
Yeah.
if they're not
Yes.
presented.
Well, as I understand it,
Sorry, becomes a legal one. So
Yes,
an
it
employer
does.
will not debate whether you have a disability. If you
Mhm.
say you have a disability, then you have a disability until they have to contest it.
Yes.
If something happens, you understand what I mean?
Because what I'm saying, if it's on a site,
Mm.
this job
Yeah.
that I used to do, you know, what I was told, you can't have the job. So what happened was, we had a conversation, it was in a pub, everyone talking, and somebody said, oh, he's got an ICD, like that. And the lady who was from HR, she said, oh, we didn't know you had an ICD. And all of a sudden, it was like, can't get insurance, can't do this, can't go on site. Like, because I didn't disclose it.
Yeah.
You're not required to disclose
Yeah.
it. I think your point earlier, I think, was a very good one, Ali, which was if you could be putting yourself or other people at risk, it makes common sense to do so. It sounds to me you might have been discriminated because you had an ICD, which would be an interesting one to follow. But could I ask you, Ali, just, one of the things I think, and what you've just said, I think highlights it. I think people are very often unwilling to say, I have a disability, and I'll quote myself on that, because, yes, I've got cardiomyopathy, yes, I have got increasing heart failure, but when I was asked at work, have you got a disability? I was, no, because I don't see myself like that. But the more I thought about it, I met the criteria. And I just wonder if one of the things we as a charity could think about is, and you may already have been involved in this, is helping people to work out, as well as the legal standard, but just our own reactions to having a condition that, because, and still it would always be a personal choice, but I think there is an issue that because if we as a group of people, cardiomyopathy is a relatively rare condition, but if we raise the profile and if we ask people, and if people were, and I would expect there would be very mixed views about whether people wanted to, but it might help to frame our thinking, which makes then when we are working to try and improve the lot of all of us with cardiomyopathy, there might well be some benefit. Mm-hmm. What do you think?
Yeah, I think that's a really important thing, because I think as well there is people's own judgment around that, and I've heard people in our support groups when I was at the charity saying, but I don't feel disabled, or it's not like I'm in a wheelchair. People have, and I think that there is something around that kind of understanding and looking at. I think that would be a really good topic for one of the nurses to take, or one of the
would be something we just might want to think about, because it does strike me. I work in the field of mental health, and in mental health, it's a lot of people were for a long time very again saying they had a disability, and disability charities by and large didn't want to know people with mental health. The good thing is we've now brought those together, but I think if we can maybe just reflect and maybe, I know we've recently completed a survey, and it'd be interesting to see if there's anything in that might help us. Yeah. Is this something that we might need to take a clearer position on? Well, as you've made very, very clear, making sure that the actual decision will always rest with the individual. Okay, any other points?
Slightly different question, but thank you for the talk so far. When it comes to reasonable adjustments and the scope for what that could entail, how I know that businesses don't have to kind of put themselves at a disadvantage, particularly disadvantage to do it, but if, for example, you worked in an industry where long hours or crazy shifts were normal, but you wanted like a 9 to 5, that would impact the profitability of the company if you did a 9 to 5, even though a 9 to 5 is, standard working hours. Is it an objective or subjective view on reasonableness, i.e. for that business, or is it what the average person thinks 9 to 5 is normal? Or is it the fact that that 9 to 5 is outside of that business's usual working thing, even if the usual working thing is excessive?
I think looking at it from a legal perspective, it will be down to the contract.
Okay.
I think it is very much down to the contract, because if your contract is 9 to 5 with the kind of, you have an hour lunch break or you have this, that and the other, then if you're having to work very, very different, extra hours, or at times that are not where if your contract says 9 to 5, 9 to 5, 9 to 5, and they want you to come and do the same amount of time in an evening, then I think it would come down to the contract first. I really do. I think it would be looking at that employment contract. If an employer was, and also it's a cultural thing as well. Is there a culture where, because I've worked in some charities where you start at 9 and you knock off at 5, but there's other charities where where there's a culture of working through lunch and people are working later and later and later. Not Cardiomyopathy UK, they were fabulous. So I think it's down to contract and culture rather than objective and subjective, really. And I would be looking at that, as a judge, would be looking at the employment contract. Does that kind of...
I'm just thinking of industries that are, the employment contract says 9 to 5 and anything else that may be required. A lot of contracts are drafted in that type. It's like the opt-out for the 48-hour working hours. A lot of contracts now are drafted in that way. So, and the prevalent... or the prevalent mode of working in that industry may be presenteeism, like you say, it's expected that you'll stay later. I was just thinking what the scope of reasonable adjustments for that is, because it's most people looking at that industry who work 9 to 5s will think that's crazy. Why are you working like that? But in that industry, that's entirely usual. And the contract will never say you have to work 90-hour weeks. It will say, and you're right. Some employers will kind of try and push that a little bit by saying, and any other type. What is it that the charity or the organisation deems fit or requires? But I would still push that back. I would, and because people don't push back, then you get this culture of, well, that's what we do. And, I remember a staff member last week saying to me, I wish we had hammocks in here like Google, and wish we had all this stuff. And Google have all this fantastic stuff. And I was like, what you don't realise is Google put those hammocks in because you're expected to work an 18-hour day. You might be 9 to 5 contracted, but because you've got all these, like sleep pods, because they want you to stay longer. But I do think, again, I bring it back to, you have to kind of push back with that. And if you have a condition like cardiomyopathy, then, the charity would support you support people to push back on that. I don't think it's, I think we see too much of this kind of culture of stretching people's goodwill, I think. Mm-hmm.